Howdy there, it's Seth here with Debrosland. In this week's video, we're going to be talking about deed titling and why it's so important to you and your family. As time goes on, real property changes in terms of what its use is and who it's going to be transferred to after you are gone. So with that, let's dive right in and let's learn more about deed titling. Before we get started, I want to make a blanket disclaimer that I'm not an attorney and the Debrosland team is not the place to ask legal questions, as no one at our company is an attorney. The best place to ask questions is to an attorney that is licensed to practice and can help you in your situation. With that, let's dive into these 3 questions you may be pondering with regard to deed titling. Question number 1. What is a deed? The deed to the property is the instrument used to convey title to the real property you are purchasing. This is something anyone can generally make, but depends on the state. At Debrosland, we typically use a warranty deed or a similar type of deed and have the closing company take care of this paperwork. It is important to note that we typically purchase all of our properties with a title insurance policy because we want to protect our investment and make sure our customers can rely on our company to provide quality land with a fully marketable title. The final deed type we will use will depend on the title company or closing attorney. Question number 2. What type of deeds are there? Depending on the state, there are different names, but there are 3 deed types that are commonly used, and they are warranty deed, limited warranty deed, and quitclaim deed. Generally, we use a warranty deed at Debrosland. This conveys title in the strongest terms, as it conveys that the title has not had any issues while the seller owned the property and has never had any issues during the entire history of the property. Next is the limited warranty deed, which is the same conveyance, but as the name suggests, is limited to the conveyance to when the seller owned the property and not the previous ownership. With this version, you are typically getting a junk title because anyone can convey a quitclaim deed on any property. It is simply a deed that states if the seller has had or never had ownership of the property, that ownership, whatever amount it may or may not have been, is transferred to the new owner. This is used primarily between family members, but should be heavily scrutinized when purchasing. No matter which deed type you have, it is important, again, to use a title company or closing attorney so that you can get a title insurance policy so that no matter what type of deed is used, your investment is protected from any title issues. This is our common practice at Debrosland, and typically all of our properties were purchased with a title insurance policy because we wanted to protect our investment as well as our customers' purchase too. Question number 3. What is the difference between joint tenants and tenants in common? This is the deed titling that is used on the deed itself, so it is important to choose wisely. Joint tenants, or more commonly known as joint tenants with rights of survivorship, is used commonly between married couples, siblings, or other closely related people that want their interest to transfer to the other party on the deed upon their death. Paperwork has to be filed like everything in life, but it is much easier upon your passing for your interest to be transferred to the other party or parties on the deed. With tenants in common, you can take advantage of ownership with multiple people, just as with joint tenants. However, when you pass, a judge typically has to move the ownership from your estate to your heirs, and not the other owner on the deed unless that person is your heir. This process of going before the judge typically requires your estate to be probated where you die before anything can be brought before a judge in the county where the property is located. Make sure to have your last will and testament set up so there is no confusion on the line of succession for your estate. An attorney is your best friend to make sure you have your final last wishes set up in a structured manner that allows for easy transfer to your heirs. Questions about this should be directed towards your attorney, as the Debrosland team is not in a position to explain any of these differences or legalities related to these topics. That's it for this week's video of the week. We appreciate you watching our video, and don't forget to like, follow, and subscribe to Debrosland for more content brought to your inbox each week. Until next time, thanks for joining us.